In this video, we're going to go through questions to help you get primed and ready for that real estate examination. And that is coming up next. Hey, just messing. All right, look it. So the next questions are going to help y'all on your real estate examination. Now, on the upfront, check it out. We really appreciate all of the support that you've been giving us for us to put out more free content and support y'all. If you can just please like and subscribe. That would mean the world to us. We've been working pretty hard at this stuff. I love to teach. I'd love to continue to teach and offer this stuff up on YouTube. It means a lot if you could do that for us. So without further ado, so question number 1. If you are the listing agent and your sellers accept a written offer, what is the first thing that you should do? Is it letter A, sign the offer on behalf of the seller? Letter B, sign the offer on behalf of your broker? Letter C, notify the buyer? Letter D, notify the buyer's agent? Question number 1, if you are the listing agent and your seller accepts a written offer, what is the first thing that you should do? And the answer is letter D, notify the buyer's agent. So some of the things that we need to make sure that we have down is our agency sort of rules and regulations. You need to be familiar with agency. You need to be familiar with buyer's agent, seller's agent, non-agent, facilitators or transactional brokers, dual agent, and designated agent. So we're going to remember all of those. And then you want to kind of know what the protocol and procedure is. So typically here in this question, what they did was they took it and they said, well, what's the sort of the path of least resistance? Well, obviously, we need to notify the buyer, but the idea here is that if we're acting in the capacity of a listing agent where we're representing the seller, then we need to notify the buyer's agent if there is one. Now, if there's no buyer's agent and there's only a buyer, then we have to notify the buyer. However, we've established the sort of protocol and procedure to do that, okay? So we want to definitely know that. Good question to start us off. The field is agency. Question number 2, when considering sales contracts or offers to purchase real estate, the most common contingency used is letter A, the right of first refusal. Letter B, financing. Letter C, title insurance. Letter D, escalation clause. Question number 2, when considering sales contracts or offers to purchase real estate, the most common contingency used is, and the answer is letter B, financing contingency. Okay, so another way that we can put the financing contingency, another way we can say it, is the mortgage contingency, which is more the normal way, but they might call it the financing contingency like they did in this particular question. So just be mindful of that stuff. Again, the mortgage contingency is the number 1 contingency in most modern transactions, especially when we're comparing it to, let's say, the right of first refusal here. The title insurance clause, which is fairly standard, the marketable title clause is really what they call it here. And then the escalation clause is a clause that comes into play if there's sort of this bidding war strategy. Lots of folks are putting in offers and you put in an escalator clause that says, look, whatever the highest and best is, I'll go, $5,000 above that. Incrementally, of course, many times that you'll see the escalation clause. But the financing contingency, aka the mortgage contingency, is typically the most common contingency used. Question number 3, when does a purchase and sales agreement become a contract by law? Letter A, when both parties and their attorneys verbally agree to the terms of the contract. Letter B, when specific performance has been met. Letter C, when both parties have agreed to the terms and signed the contract. Letter D, when the transaction closes and possession of the property changes hands. Question number 3, when does a purchase and sales agreement become a contract by law? And the answer is letter C, when both parties have agreed to the terms and signed the contract. Okay, so we need to remember a couple of important key topics here in contracts. Number one, the topic is contracts. Number two, these are contract fundamental questions, this kind of question. You want to know basically things like what is the statute of frauds? Certain types of contracts need to be in writing in order to be enforceable in a court. Real estate contracts typically have to be in writing, right? Unless they're enforceable just between the parties. But in a court, they have to be in writing. And the standard purchase and sales agreement, if they've referenced here in the question, is a real estate contract. So they're saying, when does this thing become law? Well, it becomes law when both parties have agreed to the terms and had a meeting of the minds and signed the contract. When both parties and their attorneys verbally agree to the contract, well, it's an oral agreement, doesn't make a contract enforceable per the statute of frauds, specifically in our case for real estate contracts, and the purchase and sales agreement is a real estate contract, so we kick A out. When specific performance has been met, well, they're throwing in a fancy phrase here. Remember, specific performance is asking the court to force the other side to tender the deed because they defaulted. That is an absolute probability on real estate examinations. The definition, look it up, specific performance, but that's not the reason here. And then when the transaction closes and possession of the property changes hands, well, that's not when it becomes law. That's when the contract is fully executed. Remember, we learned the difference between executory contracts and executed contracts. So again, when you're learning this kind of stuff for contracts, stick with the contract fundamentals, review those contract sections in the materials that you guys are focusing in on, and look to those standard phrases: statute of frauds, executed versus executory, and when is a contract officially, legally a contract? And that's when we had a meeting of the minds and all the parties agreed to the terms, and then they signed the contract. Question number 4. If a buyer submits an offer on a property and the seller accepts the purchase price but changes the proposed closing date by making a note and initialing the change, what is the status of the original offer? Is it letter A? It is considered to have been countered because the terms were changed. Letter B. It is considered to be accepted because the purchase price was agreed upon. Letter C. It is considered to be void because the seller made an unapproved change to the original offer. Or letter D. It is considered to be accepted but voidable pending the buyer's approval of the change. Question number 4. If a buyer submits an offer on a property and the seller accepts the purchase price but changes the proposed closing dates by making a note and initialing the change, what is the status of the original offer? And the answer is letter A. It is considered to have been countered because the terms have changed. This is an excellent contract offer question, and it covers a lot of ground. And again, it's long-winded, so it's annoying, right? Like we have to read all of this, and we have to kind of go slow, and we have to read the long-winded answers and everything else. Part of the approach of a test writer is to kind of tire you out, to make mistakes, right? So number one, we have to watch for that. Number two, we need to understand some of the fundamentals of contracts. What happens during an offer and an acceptance of said offer, or an acceptance or a partial acceptance. Again, we need to know all of these outcomes. So if an offer is presented and if it's not entirely accepted, then it's rejected. So basically, that's what this test question was looking for. It was basically saying, hey, listen, if a buyer submits an offer on a property and the seller accepts the purchase price but changes something else, it's arbitrary. It says here the proposed closing date in this particular situation, making a note and initialing the change. Well, this is a counter offer. This isn't the offer. So what? We agreed on price. We didn't agree on all of the terms. We need to have a meeting of the minds, right? So we have an offer, and then we have a rejection of that offer, and then we have a counter offer. So that's basically what's happening here. It is considered to have been countered because the terms were changed, period. It is B, not considered to be accepted, Not accepted just because they accepted the price, but if all of the other terms aren't accepted, we're still not there. We're not meeting of the minds. We have an offer, but we don't have an acceptance of the offer, regardless of the fact that we accepted price. This is a classic wrong answer. A lot of students think that just because I accept your price in the offer means that now we have an accepted offer. No, we have to have an entire meeting of the minds. So all of the terms, if we change the closing date like we did in this scenario, then we have to go back, and now we have a rejection of that offer and a counter proposal, okay? Letter C here, it is considered to be void because the seller made an unapproved change to the original offer. That's not true. It's not voided because the seller modified or amended their position or their intent in the contract. That's the negotiation phase. That isn't void. It is considered to be accepted but voidable pending the buyer's approval of the change. That's just throwing in a bunch of fancy phrases to see if they can confuse you. So it is considered to be accepted but voidable. All right, contracts, generally speaking, are voidable in certain instances when they're presented and they're lacking certain things. There could be an issue like with a minor or something like that you learn in the Contract 101 courses that y'all are going to be taking for this particular license exam. But it's considered to be accepted, not accepted, because we have a rejection of some term. So it's not accepted, but voidable pending the buyer's approval of the change. If the buyer approves the change, then the seller is countering, and now the buyer is the offeree. So that's not the answer. The answer all day is letter A. This is an excellent question to learn a lot from basic contract fundamentals. Question number 5. If a broker produces a ready, willing, and able buyer for a property, but the day before closing the seller changes their mind, the broker's commission is letter A, forfeited. Letter B is due from the buyer. Letter C is due from the seller. Letter D must be renegotiated with all parties. Question number 5. If a broker produces a ready, willing, and able buyer for a property, but the day before the closing, the seller changes their mind, the broker's commission and the answer is letter C is due from the seller. All right, so in real estate courses, we typically learn that when a broker completes their objective, they produce a ready, willing, and able buyer, ready to act on the seller's terms and conditions. They are the procuring cause. They're duly licensed and all of those other pieces, obviously. Then when, if in the buyer's, the seller's best interest, they decide to back out, but at the last minute for no good reason, there's a case law where we see these things kind of happening. And there's a possibility that there could be an entire commission owed in this particular example. Now, remember, this is a national question. There's a difference here. Some of the states that you're going to be working in, if you're, doing a state-specific, course, some states, like here in Massachusetts, for example, they disallow, basically, if the seller backs out for no good reason, there could be some kind of compensation that's owed to the broker, but really the state is looking for a closed transaction. And the case here is they call it the Tristram's Landing case. So there's a case here that establishes that generally speaking, the deal has to close in order for a real estate professional to get paid. However, in this particular example, this is a national question. So in this case, if a broker produces a ready, willing, and able buyer for a property, but the day before the closing, the seller changes their mind, then the broker's commission in this particular instance on the national side of the exam is then due from the seller. Question number 6. In order to be valid, all listing agreements must have letter A, the principal broker's signature. Letter B, an expiration date. Letter C, a renewal date. Letter D, seller's permission for the property to be listed in the local MLS. Question number 6. In order to be valid, all listing agreements must have and the answer is letter B, an expiration date. Okay, so we want to review listing agreements and some of the fundamental parts of a listing agreement. You sometimes see them on examinations where they say all of the following are essential elements of a listing contract, except that kind of thing. One of the things that you learn outside of straight up contracts, you learn those 5 essential elements in a contract, things like offer, acceptance, consideration, that whole thing, consent, legally competent parties. In a listing agreement, we want to remember that there is an expiration date. So there has to be some kind of an expiration date in order for a listing to be valid. Question number 7. A real estate agent is showing a property listed by another brokerage in the MLS. The agent has been working with the buyer for several months but does not have an agency contract with them. This real estate professional has a fiduciary obligation to, is it letter A, the buyer? Letter B, the seller. Letter C, both parties. Letter D, neither party. Question number 7. A real estate agent is showing a property listed by another brokerage in the MLS. The agent has been working with the buyer for several months but does not have an agency contract with them. This real estate professional has a fiduciary obligation to, and the answer is letter B, the seller. Okay, so we want to know the relationships. So in this particular question, it says a real estate agent is showing a property listed by another brokerage in the MLS, which, by the way, stands for the Multiple Listing Service. The agent has been working with the buyer for several months, but does not have an agency contract with them. So therefore, period, because they don't have an agency contract with them, then in this particular instance, with nothing else said in the test question, the fiduciary obligation is owed to the seller. So this is what they call seller's sub-agency. Look into that in your textbooks, and you'll see what seller's sub-agency is as defined. But that's an important one that you're going to see on exams potentially. It's just kind of, do you work for this person or do you not? Now, classically, the classic wrong answer is the buyer. And then the number 2 wrong answer here happens to be neither party potentially. That's what a lot of students might pick. But the seller is a representation in this question of what a seller's sub-agency is. So if there's nothing in writing between the buyer and the agent, then if you're showing properties that are already listed in the MLS, according to the MLS, the Multiple Listing Service, then your role is now you are a sub-agent working for the original brokerage that listed the property in MLS, and you are working underneath them for their client, and their client is the seller because their listing is in the MLS. Good question that you might see. Question number 8. The property taxes for a home that is for sale and scheduled to close on May 15th are paid in arrears. If the taxes are $7,585.40 per year and the closing date is owned by the buyer, what is the debit credit at closing? Is it letter A, credit the seller $75.85.40? Is it B, debit the seller $28.05.30? Is it letter C, credit the seller $4,780.10? Letter D, credit the buyer $4,780.10. Question number 8. The property taxes for a home that is for sale and scheduled to close on May 15th are paid in arrears. If the taxes are $7,585.40 per year and the closing date is owned by the buyer, what is the debit credit at closing? And the answer is letter B, debit the seller $28.05.30. Okay, so definitely you're going to want to review your prorations, tax prorations, knowing that real estate taxes could be paid in advance, could be paid in arrears. Arrears simply means that, you're paying for, like a mortgage payment, for example, is in arrears. You're paying for April's mortgage interest on May 1st. So you're paying for the previous use. You're using it and then you're paying for it in arrears. In advance is it's about to be billed and you're paying in advance of that bill coming out. All right, so that's the difference. And then here we're just doing some basic prorations and looking at it on a closing date and who gets the day of the closing. And so in this particular case, the answer is we debit the seller $28.0530. Question number 9. The taxes on a home are $2,878.50 and are paid in advance. If the closing is scheduled for October 30th and the buyer owns the day of closing date, what is the debit and the credit at closing? Is it letter A, $496.82, credit to the seller? Is it B, $496.82, credit to the buyer? Letter C, $2381.57, credit to the seller? Or $2,381.57 debit to the buyer? Question number 9. The taxes on a home are $2,878.50 and are paid in advance. If the closing is scheduled for October 30th and the buyer owns the closing date, what is the debit and credit at closing? And the answer is letter A. The taxes, so the amount owed is $496.82, and this is a credit to the seller. Okay, again, we want to review your debits and credits. You want to look at the prorations or the closing units in your textbooks, and you want to kind of review how you calculate taxes in advance, taxes in arrears, something in advance, something in arrears, and you want to know who gets the day of closing, and you kind of want to understand how the calendar works. All of that is going to go into being able to figure out these types of questions. They're relatively easy, and again, the letter A is your answer. Question number 10. If a seller agrees to a listing agreement with a 5% commission, has $3,435 in closing expenses, and nets $492,465 from the sale of their home, what was the sale price? Is it letter A, $495,900? Letter B, $522,000. Letter C, $540,900. Letter D, $541,250. Question number 10. If a seller agrees to a listing agreement with a 5% commission, has $3,435 in closing expenses, and nets $492,465 from the sale of their home, what was the sales price? And the answer is letter B, $522,000. So a few of the things that we want to be able to do here is sort of reverse engineer the math, and many times that'll help. Sometimes what you can do is you can, use the answers, go $522,000, and then figure what a 5% commission is based off of the $522,000, and then you subtract that, or you can add that commission to the $3,435 in closing expenses, and see if it nets you or equals $492,465 from the sale of their home. So you can use reverse math to sort of get there, and that's an easy way to kind of approach these commission, closing costs, what did we originally start with, and what did we end with style questions. Okay, that was more questions, and I hope you found these questions useful and helpful. Again, really pay attention to some of the fine points of these questions and study those topics that I reinforced during our review of these. I hope they serve you well, and I hope they lead you to passing this section of the exam. Please, respond to us in the chat. If you know someone that can benefit from this, please share this, like and subscribe if you can, because we're always putting out new materials in all kinds of different variants when it comes down to getting your real estate license and some of the foundations and the fundamentals of business and the foundations and fundamentals of real estate property, generally speaking. So it was a pleasure to be with you during this segment. I look forward to doing more like this in the future, and we'll see you very soon. Good luck on your exams.